Republic Act 9262, Violence Against Women and Their Children, also known as VAUSI. This act shall be known as the Anti-Violence Against Women and Their Children Act of 2004. The law seeks to address the prevalence of violence against women and their children by their intimate partners, like their husband or ex-husband, live-in partner or former live-in partner, boyfriend or girlfriend or ex-boyfriend or ex-girlfriend, dating partner or former dating partner. The types of violence which are covered and punishable under this act are physical violence, sexual violence, psychological violence, and economic abuse. Physical violence refers to acts that include bodily or physical harm, while sexual violence refers to an act which is sexual in nature, and to name a few, this includes rape, sexual harassment, acts of lasciviousness, treating a woman or a child as a sex object, making demeaning and sexually suggestive remarks, and physically attacking the sexual parts of the victim's body. While psychological violence refers to acts or omissions causing or likely to cause mental or emotional suffering of the victim. And to name a few, this includes intimidation, harassment, stalking, damage to property, public ridicule or humiliation, repeated verbal abuse, and mental infidelity. Lastly, economic abuse, which refers to acts that make or attempt to make a woman financially dependent, and this includes withdrawal of financial support or preventing the victim from engaging in any legitimate profession, business, or activity, and this is subject to Article 73 of the Family Code, and as well as the deprivation of financial resources and the right to the use and enjoyment of conjugal assets. This also includes destroying household property and controlling the victim's money or properties, as well as controlling the conjugal money or properties. Children, as defined under this act, refers to those below 18 years of age or older but are incapable of taking care of themselves. These are biological children of the victim and other children under her care. The VAUSI does not only cover a legally married couple. This also includes dating relationship and sexual relations. And dating relationship is defined under this act as a situation wherein the parties live as husband and wife without the benefit of marriage, while sexual relation refers to a single sexual act which may or may not result in the bearing of a common child. Battered woman syndrome, as used under this act, refers to a scientifically defined pattern of psychological and behavioral symptoms found in battered women as a result of a long history of abuse. And this act acknowledges that women who have retaliated against their partner or who commit violence as a form of self-defense may have suffered from battered woman syndrome, and this shall be proven in order to afford of the justifying circumstance under the revised penal code. Who are now the persons protected by this act? These are the wife, former wife, a woman with whom the offender has or had sexual relations with, a woman with whom the offender has a common child with, and a legitimate or illegitimate child of the woman within or without the family abode. Vowsy is not limited by men alone. Women can also be liable under this act. These are the lesbian partners or girlfriends or former partners of the victim with whom she has or had a sexual or dating relationship. And with regards to male spouse or partner who complains about abuses committed by his wife or partner, he may file a complaint under the revised penal code because spousey does not cover abuses against male spouse or partner. The women and children who suffers violence or abuse may file a criminal action or apply for a protection order, are either as an independent action or as an incident in civil or criminal action, as well as other remedies. Any citizen having personal knowledge of the circumstances involving the commission of the crime may file a complaint because VAUSI is considered a public crime. Cases for vowsy may be filed in the RTC designated as a family court of the place where the crime was committed because these courts have original and exclusive jurisdiction over these cases. The penalties for committing vowsy are imprisonment ranging from 1 month and 1 day to 20 years and payment of 100,000 to 300,000 in damages plus mandatory psychological counseling or psychiatric treatment. The prescriptive period for filing a complaint for VAUSI is within 20 years from the occurrence or commission for the acts under sections 5A to 5F, while 10 years for the acts under section 5G to 5I. What is now a protection order? Protection order is an order issued under this act for the purpose of preventing further acts of violence against women or her child. This is a relief granted by the court or by the barangay for the purpose of safeguarding the victim from further harm. What are now the kinds of protection order? These are, first, we have barangay protection orders, also known as BPO, and this is issued by the punong barangay, ordering the perpetrator to desist from committing acts under Section 5A and B, and a BPO shall be effective for 15 days. Second, we have the temporary protection orders or TPO, which refers to the protection order issued by the court on the date of the filing of the application. And a TPO shall include notice of the date of the hearing on the merits of the application or on the merits of the issuance of a PPO. TPO shall be effective for 30 days and it may be renewed for another 30 days if there is no hearing yet for the application for a PPO. Lastly, permanent protection order or PPO refers to the protection order issued by the court after notice and hearing, and PPO shall be effective until revoked by the court. The application for protection order may be filed with the RTC or designated family court or municipal trial court for petitions for temporary protection order and permanent protection order, while barangay protection order may be applied for in the barangay where the applicant resides. Who may file now for a petition for protection orders? These are the offended party, the parent or guardians of the offended party, the descendants, or collateral relatives within the fourth civil degree of consanguinity or affinity, officers or social workers of the DSWD, or social workers of LGUs, as well as police officers, punong barangay or barangay kagawad, lawyer, counselor, therapist, or healthcare provider, or at least two concerned responsible citizen who has personal knowledge of the offense committed. The BPO shall be issued within 24 hours from application, otherwise the barangay official assigned will be held liable. And the TPO and PPO are enforceable anywhere in the Philippines. That would be all. Thank you.